Any mention?
Please, Lordship. Lordship, with your kind indulgence, I beg to mention item 27 to 110, my lord. These are all with regards to the issuance of NOC by the SORA, CM of SORA, Lordship.
Why is your interest that they get disposed of fast?
My lord, Mr. Day is on leave. He is arguing the matter. So I'm praying
You're
it will
there.
be taken up. I'm not very well versed, Lordship, with this. Next week, Lordship, I'll try to finish it.
Your Honor, with the contempt, we have already filed the compliance report from January last year. And with regards to the writ, they are subsequent writ, and some of the licenses are 14 years, 20 years expired, 2004, 2007, 2009. There are 18 retailers and 22
Yes, it's
exporters.
all right, ma'am. Yes,
And no shop has been stopped or been
where he's on
closed.
sanction leave.
Lordship.
He's on sanction leave. Yes, as the Lord Counsel for the petition sanction leave, this is matter after 2 weeks. Yes.
27 to
Also,
110, my lord.
27 to 110.
Lordship. All the
It's contempt, we have already complied, Your
usually
Lordship.
filed, my lord.
And these
So
exporters.
contempt, we take up the contempt only then.
Yes.
Lordship, I have it on the next at the same time because they've been tagged together, my lord.
Okay, yes. 26 to?
27 to 110, Lordship.
Very good, yes.
Surprise, Lordship. Lordship, I also have a similar prayer for item 15, my lord.
Item?
15, Lordship, 1-5. For the district council, Lordship.
15.
You can consent from the other side.
Yes.
No objection, Lordship.
Yes.
May it please your Lordship. Lordship, supplementary list, the last item of hearing, your Lordship. I got a wrong, they have sent me a wrong file. So next week, your Lordship.
After 1 week, yes.
Lordship. Obliged.
Request for the AAG, supplementary list after 1 week.
Obliged, Lordship.
Yes.
Please, Your Lordship, I beg to make a mention in item 25.
She is there. You're there. 25, which one?
Deepali, it's for cancellation of patta, Lordship.
Why?
Lordship, senior counsel is out of station, Your Lordship.
He's out of station, we know. He can come to the little
Some
box
personal
here.
difficulty, Your Lordship,
Yes.
that's why he couldn't appear.
Yes?
Because some personal difficulty, Your Lordship.
Where's Mr. Thapa?
He's out of station, Your Lordship.
He's out of station also.
Yes, Your Lordship.
2 weeks, yes.
Obliged.
Yes.
Your Lordship, I beg to mention item 17, Your Lordship.
7?
17. The consent of the petitioner has already been sought, Your Lordship.
You're for the
Sir,
petitioner
I'm
for respondent.
For respondent, Your Lordship.
2 weeks, yes. Yes, Mr. Pathak. 2 weeks.
Item 17 was kind of similar with item 18, 19 and 24.
Oh. You're ready to argue the matters today?
But then Mr. Chanda, my lord, he is not ready today. So let them come up together, my lord. Item 18, 19 and 24.
And 24, yes. After 2 weeks.
Much obliged.
Right. 23? Or 23? Yes.
Not 24.
Yes.
Your Lordship, I beg to mention item 21. I think that this matter may be adjourned for today.
Too many adjournments. 21.
Yes, Your Lordship.
No objection, Your Lordship.
We'll never have objection of me. Yes, 2 weeks. 21, yes.
I oblige.
Obliged, Lordship.
Please, Lordship. Lordship, I beg to mention item 12, Lordship.
Number?
Number 12. It's a joint request by both parties, Lord.
Your Lordship.
This is that pasting of the picture in regarding the defaulting.
Yes, Lordship. Full default.
Why 19 matter 1 week, yes.
Yes, Lord.
Yes.
Similar prayer for item 16, Your Lordship.
Very good.
Lordship,
Matter may come next week, Lordship. Next week.
Lordship, it's means it's long pending case, and we have already realized the amount. Now they are lingering on this case. Last occasion also, my learned senior, he was not available.
Monday?
He sent his.
Yes, Lordship.
Monday?
It's next week's election, like when
Because too much adjunctive from your chamber also, you see. You can't, like, what do you call this, able the functioning of the court also.
We
If
have
the
already
senior is not
realized
there,
the
at least the
amount.
junior should be ready to argue the matter. Otherwise, we'll just hear the matter looking at the records.
it's next
So
week.
1 week, yes.
But not on 28, Lordship. 28, I have matter in Guwahati because since all the matters we set up like that, the cases,
Yes,
and
okay.
they come up with adjournments every now and then, and without prior information, Lordship. After I reach court, they inform me. That is also.
So you pay a cost. You come by own car.
Yes.
You to pay petrol cost, then for her lunch. Does that be the new norm now? You actually don't inform them. You pay for the conveyance. You pay. It's like they call it TADA in official circles. You have to pay that. You pay that. Okay, for this time we'll spare you, but next time you pay 1,500 rupees for every German you take. Okay.
Congratulations.
Congratulations.
My lord. Item 22, my lord.
Was it heard in part? This one, no.
Partial, my lord, with regards to the court of inquiry which wanted to call for the court of inquiry.
The records have come. You want to do it? You want to upgrade it, or you want to adjourn it?
Adjourn.
Okay, 22 matter after 2 weeks. Yes, that request was asked due to personal difficulty. Yes. Call out the list.
Hello.
Supplementary list item number 1.
Move petition. None appears for the petitioner just after 1 week. Yes, next.
Two.
Yes, Mr. Tim.
Lordship, in this matter, what has happened is the petitioner, my lord, was appointed as an ad hoc teacher in the erstwhile Ampati government aided school, my lord, high secondary school.
When?
In the on 21st of July 1989, my lord. It was against the sanction post. Thereafter, my lord, after serving for a few years, lordship, about 10 years, she submitted a request for regularization of her service, lordship. Lordship will find that at Annexure 3, my lord. Annexure 3, page 35, my lord. 36, lordship. 36 is the prayer, my lord. And
Annexure 3 is? Okay, this is
the prayer, my lord, which I have submitted for regularization. And in pursuance to that prayer, lordship,
98.
lordship, I have been regularized with effect from 28/10/1996, lordship, by a letter of 1st September 1998, my lord.
Okay.
Thereafter, my lord, after serving for another 12 years, in the year 2010, my lord, 13th of October, I was transferred and posted as the LSEO, my lord, Lady Social Education Officer, under the in the West Garo district.
Yes.
On 2017, my lord, 3rd of April 2017, a letter was issued by the department, my lord, seeking for ex post facto approval of my service, my lord. Various communications, my lord, were exchanged departmentally, and till the year 2021, my lord. And
that means it was never regularized in the regular manner.
Appears.
The inspector of schools was not a competent authority.
At that point of time, my lord, he was.
Who was he?
Inspector of schools.
He was not a competent authority.
At that point of time, he was the competent.
Then what happened after that?
Thereafter, the director has come and all that. So anyway, my lord, they had requested for ex post facto approval of my regularization.
Yes.
By a letter of 10th of February 2022, my lord, it was informed that the matter is under examination with the department, with the cabinet, my lordship. Thereafter, lordship, we waited. By a letter of 23rd of June 2022, my lord, the list was given, published, lordship, for the persons who were regularized by the cabinet on 15th of March 2022. My name was there, my lord, approved by the cabinet for regularization, lordship. In the meanwhile, lordship, on 1st of September 2022, my lord, I applied for VRS, having completed the required years of service, my lord. I applied for VRS on the ground that I was wishing to contest the election from Ampati constituency in the Congress ticket, my lord. A letter was given to me, my lord, by the special education officer on 29th of November, saying that I was not yet regularized. Thereafter, my lord, again I have submitted a representation bringing into record all the details.
Now you say that by this letter dated 23rd June, you were regularized.
Lordship.
Right?
Lordship.
Okay. Where are the names? You see, it's on inviting reference subject. I'm ready to say that the following ad hoc appointees under a department are approved by the cabinet for regularization subject to the condition that is so and so. Anyway.
Yes, Lordship. My name is at serial 5, my lord, of the typed copy at page 43.
Okay.
Annexure 5, page 43, typed copy, number 5, Srimati UG Sangma, my lord.
UG Sangma. Okay, okay. Then what happened now? What are you aggrieved with?
I am aggrieved by, my lord, it's a very peculiar situation. When I was desirous of contesting the election, my lord, they had stated that I was not yet regularized, so they cannot give me VRS. I approached this court, my lord, to ask them to take a decision and to dispose my request for VRS. They came up with a letter, my lord, which was brought into record of this court, saying that the same thing again, that it cannot be regularized, it cannot be processed because I am not regularized, my lord. In view of that letter, my lord, the writ petition was disposed of on 2nd of February 2023, lordship.
Yes.
2nd of, in the elections, my lord, the nomination started from 2nd of February itself. So I have submitted having no other option, my lord, I submitted a resignation that came to be accepted on the next date. Thereafter, my lord, I contested the election. Unfortunately, I did not succeed. Now, my lord, my prayer is that my service was initially regularized, my lord, with effect from 28th of October 1996. And thereafter, my lord, it was again ex post facto approved by the cabinet.
Okay, you take notice. Yes, who's appearing for the state?
Lordship, if I may just take your lordship to page 43 as stated by my friend. The list of names is with regard to transfer, lordship.
Yes, it's all right. You take instructions.
Lordship.
If the work is against sanction post, there's no question of service being temporary any longer. I heard Mr. S. Debney, counsel for the petitioner, issue notice returnable in 4 weeks. MS NG Shila, senior government advocate.
Senior government advocate, lordship.
Advocates present accepts notice on behalf of all the respondents. No further notice called for. Just after 4 weeks for instruction stroke affidavit.
Much obliged, my lord.
Obliged.
Main list item number 1.
Yes.
Your Lordship, the state has to come with instructions regarding the fire, Your Lordship.
Regarding the?
Regarding the delay in holding the DPC, Your Lordship.
No, not that. The thing is that only one point. Where's your senior? He's not here today.
Today, Your Lordship.
The only one point that you raised is that the affidavit was filed by the state respondents did not give the correct picture with regard to why DPC is not held. That's the only thing.
Your Lordship, malified intention, Your Lordship.
Mr. Abraham?
Yes, Your Lordship. In this case, in the first round of litigation, they have never met any malafide. But in this petition, almost
review is very limited. If we're not going to go here and there, it's only that if there's anything that is new, that that would have had an effect on the early adjudication, which will maybe the review may be allowed and looked at as well.
Yes.
If you have to show that it has no effect and the the review is not maintainable or there's no grounds have been made out.
So
You start, yes.
If that's the case, then Your Lordship, may can you fix the matter on another date, Your Lordship? My senior will be arguing himself personally, Your Lordship.
You argue it, what's the problem? You put down a challenge, they have to answer it.
Not well versed for the matter, Your Lordship.
It's not being well versed. This is matter after 2 weeks.
That is right.
On the request of the council for the review petition.
Item number 2.
You'll be ready on the next date. We'll dispose it off.
Contempt petition. Respondent number 3 had filed his affidavit and we had filed our affidavit in reply. Respondent number 1 and 2 have not yet filed any response to the contempt petition. On the last occasion, Lordship had gone to the extent of giving them a liberty to file a common affidavit bringing on record all the facts. Even that has not come on record today, my lord. They are simply delaying the matter, waiting for something to happen.
This is correction. Which order?
My lord,
this is with regard to
state to be violated.
My lord, that Lordship will find at page 27, my lord. This was regarding the transfer policy posting of the doctors in the
specialist doctors.
Doctors and all where Lordship had.
My lord, then
Policy was framed. Now what they try to say is in their affidavit in opposition of the respondent number 3, a straight statement has been made that we are not implementing the policy. That would have been enough for the contempt to have been taken up, my lord. But respondent number 1 and 2 are not.
The thing is that it was before the division bench where they asked to take a call.
Case. That was recorded in the last order also. That division bench order was pointed out. It was in one particular case where the transfer thing had started even prior to the policy coming into force. And therefore the division bench has given them 3 months time to take a decision. Now Lordship will kindly see that 3 months, that was done on 31/1/2023. They have less than a week to complete that 3 months, and yet no response. Even if you take it with 3 months, in April it expires. No response before this honorable court.
Where is that order?
My lord, the
31/3/23.
My lord, yes.
What have you done?
My lord, the decision has to be taken at the level of ministry, my lord. That is the direction by the division bench, my lord. 3 months time was given, my lord. We still have at least some more time, my lord. Some 10 days,
not even a response by respondent number 1 and 2.
It's all contingent on this decision. That's what we're waiting. We'll have it after 2 weeks.
My lord. In the meantime, whatever happens, my lord.
Whatever happens, you file affidavit. You bring on record. Then whatever will follow will follow.
On the last occasion, Lordship had given the liberty to file a common affidavit.
Yes.
Even that is not coming up.
No, they're waiting for that time to expire.
My lord.
We'll start for 2 weeks. Yes. At the request of Dr. N. Mozika, who submits that the matter is under consideration by the ministry, this is a matter of 2 weeks. It is expected by on the next date, said affidavit will be on board. Yes.
3.
We'll have to drop contempt proceedings then. We'll have no choice.
The Delhi High Court a few days back had upheld that policy.
Okay, you bring that order.
At that order, I had given him a copy for his convenience. Even the Delhi High Court has upheld the policy. Obliged.
Yes. Yes.
My lord, in this matter, I've been instructed to appear for district council, my lord. Khasi district council.
Who was appearing before?
Mr. Dingdo. Mr. Dingdo. TT Dingdo was appearing, my lord.
Where's Mr. TT Dingdo?
Now they've instructed me to appear, my lord.
So what to do?
Lordship, so far the state is concerned.
No, today is first. You've taken steps.
Yes, Your Lordship, we have taken steps on 4 to 6.
Yes, on 4 receive, 5 and 6
5 and
not
6
receive.
not
You
receive,
obtain
yeah.
statuses.
I'll obtain status. Your Lordship, for respondent number 6, the postal receipt says it's delivered, Your Lordship.
That is to come on record.
Yes, Your Lordship, I'll obtain status.
Yes, with regard to service on respondent 5 and 6, Ms. P. Chetri praise funds allowed 1 week's time to obtain status and file affidavit. Yes. Stop. Next one, Dr. N. Mozika today submitted that they have been engaged by respondent number
1, my lord.
Respondent 1 to appear in the matter. So, do you require any time to prepare? No.
But I'll require, because the affidavit, one additional affidavit will be required on behalf of district council, my lord.
Yes.
So, my lord, that's exactly what is given to file.
Yes, praise that. Submit says has been engaged to appear on behalf of the respondent number 1 stuff. He further submits that after perusing the earlier affidavit an additional affidavit is required to be filed to bring the correct facts on record. Stop. Accordingly, 2 weeks time.
But there appears to some Mr. Chulai, it appears that the Registrar Judicial Service, High Court of Meghalaya, whether state can
has been filed by 2, Your Lordship.
State can represent
That
High Court.
will come, the affidavit of R2, Your Lordship. Registered Judicial Service has no role to play also. What he'll do?
But whether state can
approval doesn't come Registered Judicial Service. Approval is from the state. Appointment is done by you. And only thing is that it just goes, it comes by way of information, that's all.
But only whether formally it is correct that state will represent High Court of
Cover,
Meghalaya.
the state affidavit will cover R3 also. Okay, let's go ex parte against Registered Judicial.
But whether notice has been served, it appears that Mr. Chulai has accepted notice on behalf of number 3.
Your Lordship,
Registrar Judicial Service in my
if I may, Your Lordship, Registrar General have written a letter to the state government. Thereby, Mr. Chulai has entered appearance.
Oh, he's been specially.
It's reflected in one of the order sheet, Your Lordship.
Listed after 3 weeks, Your Lordship.
3 or 4 weeks, my lord. The others are not yet represented, my lord.
Yeah, 3 weeks better. You obtain status.
2 weeks, Your Lordship.
Let them file actual affidavit.
3 weeks.
Apply, Your Lordship. File.
Regional file, my lord.
You want to listen for hearing or you want to hear it now?
Hearing, my lord.
For hearing. Yes. Parties submit the pleadings are complete. This is a matter for hearing in the usual courses.
5.
I filed my affidavit.
When you file today?
Today.
3 weeks time. 3 weeks time for rejoinder.
Mr. R does not submit that affidavit since been filed. Stop Mr. Eminent Pure pays funds allowed 3 weeks time. Start rejoinder. If thereafter.
6.
Lordship, in this matter, I have filed the rejoinder.
Pleading are complete.
There is an extreme emergency in this matter.
What's the matter about, Mr. Jindal?
Your Lordship, here what has happened that these petitioners here before Your Lordship, I think around 60, otherwise 91 petitioners, they were appointed by following the regular selection process against the sanction vacant post. But appointment was given on a temporary on fixed salary, minimum wages. The state continued to take their services for more than 10 years. And after 10 years, they say we will regularize you through RCW. No, RCW.
This requires a detailed hearing. Yes.
Detailed hearing, Your Lordship, but there is a urgency of the matter. Your
Why?
Lordship may fix it after a week or.
There is a stay, in fact, Your Lordship.
No, stay doesn't help me so much.
Okay, parties submit the pleadings are complete.
Lordship, yes.
This is a matter for hearing after 2 weeks.
Lordship.
Yes, liberty may be given to mention for upgrading.
Mr. Jindal, it's all right. There are matters are more urgent than being adjourned. So when they adjourn that time, we can take it up within the list.
That Your Lordship.
Sir, I will not take time.
7.
Yes.
I will take time. You have no case, so you will not take time.
You'll take time, or you'll take time to argue, or you'll take time for adjournment?
No, not take time.
6 and 7 are same, Your Lordship.
8.
That interim order continue and
Interim order pass
same order. Same order.
Yes.
8.
I'm praying for 3 days' time, my lord. The concerned official is coming today with the file, my lord.
We'll pass orders. What's the matter about?
This is a non-clearance of the bill, Your Lordship.
Bill, my lord. Instruction
Yes.
required.
You pay him.
Actually, the person is coming today, my lord.
Which person is coming today?
The concerned, my lord, the officer from the accounts. I'm praying if it can be taken up on Monday or anytime. Try to sort it out.
No, you couldn't get telephonic instructions also?
No, my lord.
In this day and age.
They said that they wanted to some clarification, some.
You have to meet face to face to talk to obtain instructions.
They wanted to come with the file, something they wanted to.
See, if you've paid the other two contractors,
I understand.
what prevents you from paying him?
That is why, my lord, they said that there is some issue. So we are not aware what they have not given the instructions on paper, my lord.
Monday, In spite of lots of opportunity being given, Mr. S. Deb, counsel for respondent, submits that due to unavoidable circumstances, the person concerned could not be in Shillong today. Could list the matter on Monday. Yes. You don't get telephoning, otherwise then we'll direct that you pure interest. Yes.
Service is done. They are entering the appearance.
My lord, we have received this letter from the collector. So they have requested Senior GA to appear in this matter.
Requested whom?
Senior GA to represent the collector, my lord. So my lord, we will be required to file our authority, my lord.
Yes, sir. MS Arkoni, will you file objection to the condemnation? Delay will be condoned, but then let them appear first, formally.
File our authority first.
They can file another.
Yes, MS Arkoni submitted the instructions to appear on behalf of the collector, and please give some time to file a formal power. The list after 1 week.
Delay your honor.
No, let them appear first. She's not the counsel appearing for the government,
right,
for collector.
Other matters
We'll condone the delay, Mr.
Other matters are fixed on 28. So this also
It's a matter 28. We'll condone the delays.
11.
Yes, Mr.
I just raised the objection about the maintainability.
Yes?
In this case, I was just raised the objection of maintainability petition because they will go to.
Why is not maintainable?
Because petitioners to go to the cat.
Who's for the petitioner?
I can see him today.
Who's E. Joshi?
So,
which department?
It's a Northeastern Police Academy.
Oh yes, they'll have to go to CAT. Yes. He's not BSF, no. Who's for the petitioner?
I can see him today. Let it come after a week.
None appears as petitioner in interest of justice. This is matter after 1 week, yes. You prepare on that day.
Hearing
you bring a
supplementary
notification.
list. Hearing supplementary list, item number 3.
My lord, try to take a short.
I think Mr. Chandra should cut things short.
Yes.
Just give bullet points both sides.
My
Otherwise, reply then.
Yes, my lord.
We will.
My lord. For me, according to me, my lord, only 2 issues involved, my lord.
1 second.
With regard to downgradation and the promotion denial.
Today is 20th.
Yes. In that first issue, my lord, according to me, when 2 apart.
See, one thing, Mr. Chandra, before you start, only one query. Now, in your prayer, you have written for changing from good to very good,
yes,
and to maintain outstanding for the entire period, correct?
Yeah, yes.
But then in the other part of prayer E, I think it contradicts your prayer B or something, I'm not sure.
But let us see the prayer, I'll just clarify it for you. Page number 37.
1 second. 37. Just clarification on that, because that while hearing senior counsel yesterday, 37, correct?
Well, 37.
Yes. 37. Now A, okay.
A, my lord, I asked for setting aside this downgradation because without any information, without us.
Set aside and quash the impugn downgradation of the grading of the first and second part of APR of the writ petitioner from very good to good for the period 1/4/2015 to 27/7/15,
yes,
as well from outstanding to good for the period so and so.
Yes.
Yes. Now you come to E.
E, my lord.
Yes.
E, my lord. Direct the respondent NIPCO to uphold and retain the grading that is outstanding for the period such, my lord, under such NIPCO policy. Now,
and now
Mr.
General has submitted that the DPC then took a call and pegged it at very good for the entire, correct?
That is his submission. But in the document, my assessment year for this year was only good.
Only good.
And yes, when two APARs are prepared for one assessment year, my lord,
yes,
the longer duration will be prevail. Therefore, I asked for, my lord, outstanding. retention of
So
outstanding.
your case would be that fine, that part ECR for that assessment year
Yes.
was never given, communicated to you.
My
First part.
First part.
Now, and so for the whole year, you see you're doing good. Now, their contention is that it's not necessary to give a part, to communicate the part ECR to you for the assessment year.
Yes.
And that at a time promotion, the DPC takes a call looking into the two segments of that assessment year. Correct? Is that correct?
That is his contention.
Yes.
That is his current contention.
Yes.
And my contention is, my lord, when two parts are prepared, the longer duration will prevail. And when they do a downgradation, either shorter duration or longer duration downgradation is there, it is the duty of the authority to communicate me so that I can file representation to improve myself. The rule itself provides for that. Even
6.4.3.
My lord. And even, my lord, even this All India applies the rules. 2007 also provides for that communications.
That's the only thing that's troubling to this court. Regarding communication or downgrading. That's the only thing, which Mr. General says is not required because we're looking at the, at the whole year.
And I'll place one citation also. And therefore, yesterday, my lord, till yesterday, learned senior as usual vehemently argued for 3 days, 3 times. If I gather properly his argument, my lord, that the retention of the outstanding doesn't arise. That is one of his contention.
Yes.
Second is, my lord, if I summarize, the DPC held on 2017 April 2017 was not a review DPC, it is a fresh DPC. Fresh DPC. And the third one is that the denial of promotion, also called the financial benefit, was denied to him by the decision of the CMD. CMD. My lord. That is his, my lord, 3 limbs of my lord, strong arguments he advanced. I will clarify quickly regarding this. And he said that my APAR was not interfered by the authorities. Now, he had also submitted the, where may I go to? First apartment. Regarding first apartment, I'll take you RTI straight away to clarify.
That is
to clarify this point.
Where that Mr. General has given me the other thing.
My lord,
like there were 2 of them. Kawai is.
My lord.
1 second, Mr. General. Yes, the first one, 1/2015 to 27/7.
My lord, they have downgraded from very good to good, my lord. That is the first apartment.
Right.
The first apart, without informing me, and the overall yearly assessment they have taken, and page number 107, 105, my lord, they have given me for the entire year.
1 second. For 105.
My lord, page 105. Read petition. Read petition. At the bottom, my lord, assessment year 2015-16, they put good. Yesterday, my senior argued that very good. That is contradictory report. And he also said that it is not interfer. My lord, the downgradation is available in page number 106. But I don't dispute the power of the reviewing authority when I was in the HR department. Director has the power to downgrade it, from very good to good. But he has to communicate this to me. But they did not communicate to me, and this averment is not denied by the respondent in the affidavit also. And now, my lord, the contradiction, page number 108, with regard to second upper.
1 second. Yes.
Second upper, 109, sorry, 109. My lord, it says, may I read, my lord? Is the RTI reply to me through, when we go for appeal? With reference to the appeal dated such and such, this is to intimate that the rating of upper for the period 28/7/2015 to 31/3/2016, this is the second upper, my lord, is same as the rating of upper for the period 1/4/2015 to 27/7/2000, which was already provided to you by litigant-in-person and such. And this letter is, my lord, that upper is available.
No, now they say that with reference to appeal dated 22/6/2017, you have to intimate the ratings of upper for the period 28/7/2015 to 31/3.
Yes.
That means they didn't communicate to the second part or the first part?
Second part also, third part also, first part also, second part also not communicated.
Then what did they say that is same rating upper for the period from 1/4/2015?
No,
the first part to 27, which was already provided to you by letters also.
No, my lord, it is not. This is after they have done the promotion.
Okay.
After they have done the promotion, then I filed for the RTI.
Okay.
Then they provide to me, my lord. And they are saying that my upper for the second upper grading is as good, my lord, is same with the first upper, and first upper is good. The director has downgraded from very good to good, and that letter they have referred 16/6/2017 is available in page number 104. 104. This RTI reply 104. 104. And the next page 105 they have given me. Good. So they are trying to say that first and second assessment, your grading is only good. That is what the reply. And if I secure only good, then my lord, my upper, I was unable to secure 50% under the rules, the marking. And now the second upper note, which they never provided to me through RDI also, my learned senior has provided earlier. Now I'll point out, my lord, my learned senior say that this second upper was not interfered with by the authorities. But I will point out, my lord, how the direct CMT has interfered, my lord. I may come straight away. I've done the instruction.
No, but the second part, you're given outstanding.
Outstanding, and the reporting officer given me very good. And CVO, Mr. Verma, has given me outstanding.
Yes.
And the CMT has reduced to very good.
Right.
My lord. And the last page, my lord. The last page, my lord. If I show to my lord, the last page, it says 80. Total mark he has given me 80 and
80 rating,
my
80.
lord. And the 90 was given by the CVO.
Yes.
CVO. And my lord, the at the bottom, accepted above. Now the CMT say accepted the marks graded by the reporting officer in view of the, my lord, the All India Performance Appraisal Report Rules 2015. So he has accepted the approval, the report given by reporting officer. That is very good, not outstanding.
Accepted the reporting officer. Okay.
Yes. And the reporting officer
is regarded the one by the reviewing authority.
Yes. And the reporting officer report is available in the middle page, my lord. He has written very good in the middle page.
In the middle page, oh yes.
My lord, page number 4. So this was the report of the reporting officer. And CVO has given me outstanding, but the CMT has reduced it to very good.
You know, he's not looked at the reviewing authority, he's looking at the reporting authority.
Reporting authority.
And accepted what reporting authority said.
Yes.
Okay.
And he tinkered with this
Right.
report also. Report also. And now may I just another clarification. May I come to the Another point. My Lord, I'll just point out they say that in the averment, this is my duty to reply to the averment. The Lordship, Lordship, may kindly come to page number 74.
Oh, we read petition?
My Lord, page number 74. After the petition. Now, Mr. Verma, the then CBO, after he was transferred to Tripura, my Lord, he has written this report. 4 of them. Abhishek also serial number 3. See, this all 3 except Abhishek, they have accepted the report of Mr. Verma. Well, in my case, they say that it is non-enforceable. Now, may I just please, I'll keep copy to my senior also. It's out of the record, but I just show, my Lord. How the discrimination was there, my Lord. In this page 74, he was written on 17 October 2016.
17th
October. And this is the same thing, 17 October, for other 10 officers. He has written the APAR also. And all these they have accepted. They acted upon. And some of the officers also got the benefits. In my case here, page number 74, Mr. Kankan Sharma, serial number 2, my equivalent rank, he was recommended for outstanding. His APAR was outstanding. So because of that, he got the pay benefit, performance-related pay, also he got the benefits. So out of this 15, we can say 15 officers' performance report, 14 they have accepted, acted upon, except Mr. Abhishek.
So there are 14 officers.
14
accepted
officers.
13.
Yes, yes. They have accepted. Right. Now, may I come to the rules? Madam? That's another clarification. The rules, my Lord, I have submitted with the rules 1 earlier.
We'll just read this part 2 of this letter, 17 October. Just read it in respect of, just read this for the letters at page 74.
74.
Yes.
My Lord, in respect of serial number 1, Sri Akbar Hussain, General Manager, the Reviewing and Accepting Authority, with Sajjad Pankaj, the then CMT, has superannuated. May I come to
clause
2?
Clause 2.
My Lord, yes. In respect of serial number 2, Mr. Kankan Sharma, Senior Manager Civil, and serial number 2, Sri Abhishek, APAR has been reviewed and accepted by the undersigned. Since both have been awarded outstanding grading, this APAR need your counter signature.
Yes.
There is no role of
There is
director.
no role of direct technical or direct personnel spent in this matter because he's like a functional director.
My Lord, they are equivalent rank. Equivalent rank.
So what was done out here when they accepted? He was the
My Lord,
who accepted the reporting officer's assessment. This is signed by.
My Lord, this is the
CMD.
report given by CVO.
No. CVO is fine. CVO is given outstanding.
Yes.
But then accepted the marks awarded by the reporting. By the reporting officer. Who signed this one?
This letter. CVO.
No, in the APR.
No, Lordship is looking to the. Lordship is looking to that. Which one?
10, 11, 16 is the CMD signature.
Accepted the marks awarded by the reporting officer.
He did not make any change.
No, can't understand.
No, I will
If he has given
If your
outstanding,
lordship permit, I will
no, 1 second, Mr. General. If he has given outstanding, then he has. How has he said that accepted the marks ordered by the reporting officer?
My lord
And
is
marks of reporting officer amounts to very good only.
My lord is looking to page number 71.
No, I'm
74.
looking at this APR.
This one.
Yes, the last page.
Yes, the last
because
page.
then he's both the reviewing and accepting authority.
Right.
Correct, CVO. That means he's all in one.
Yes.
Reviewing, accepting authorities all in one.
Yes.
Correct.
Yes.
Then I don't understand, if he gives outstanding, he gives above 80 to you, then accepted is above, then he accepted the marks awarded by reporting officer. That's contradictory.
Contradictory. Therefore, my lord, by this 78 page 78 letter, 17th of October, CVO requested the CMD that you need to put your countersign on the. Your director do not need to the exercise.
No, then he says that that's why I'm saying this number 2.
Yes.
He said respect number 2. So forget Kankan
Yes.
Sharma. See, manager, sir, and now see Abhishek Kumar. The APRs have been reviewed and accepted. Reviewed and accepted by the undersigned.
Yes.
By the CVO.
CVO.
Since both have been awarded outstanding grading.
Yes.
Then how? Then the record APRs otherwise.
Yeah, exactly. Therefore, I say that this is absolutely illegal. He has
illegal by him, but same CVO.
No.
It's a mistake made by him then.
No, this is signed by the my lord at the bottom signature. CMT has signed this one.
Okay.
My lord, CMT at the bottom. Accepted.
Oh yes, Chairman. Yes.
Accepted the marks granted.
Right. Okay.
This is tinkered with by the CMT at the bottom. From outstanding to very good. Whereas Kankan Sharma, they retain it. And in affidavit, they say that.
Okay. Continue.
Grading given by the
Mr.
Verma is not enforceable since he was demitting from office. That was their claim. Now may I just come to the rules.
15 minutes already over.
Almost, my lord.
Yes.
My lord, I'll come to page number 5 of that rules I have submitted.
1 second. Yes. What do you want to show?
My lord, the page number 5, adverse remarks in performance appraisal. I'll do a short one only, my lord. So there is a provision for communication, even representation also.
Yes.
This is not done. I'll just point out.
You argued this earlier, I think.
Earlier I have argued, my lord. And second, another clarification where my learned senior say that the third TPC was a fresh TPC, not the, my lord, not the review TPC. I will just clarify, my lord. That is I think I'll just take it to my lord, page number 7, my lord, to clarify that point.
Yes.
My lord, page number 7 of the rules.
Yes.
At the bottom, my lord, may I just point out, my lord, the incumbents consider for promotion from E5 and E6, we are here, my lord, and above, but not recommended for promotion. TPC has to complete 1 year from the date of such rejection to become eligible for consideration of promotion for next time, second time by the TPC such and such. Now, in my case, therefore, the second TPC they held on in this March was on merits rejected me. In that case,
no, listen. The incumbents comes of promotion and above, but not recommended promotion. 1 year did suggestion to become eligible for consideration again.
Yes.
So you say that I rejected once, it's sat again when?
Well, now I was. They say that they have rejected me. I'll just show the page there. It is available in page number. My lord, may come to page number 94. Now the second TPC, the first PC, my lord, CMT has annulled everything on my complaint. Now second TPC held on page 94, my lord. It was held on, my lord, 2nd March 2017. At the bottom, 2nd March 2017. And they have given the, my lord, final promotion order, same date, my lord, page number 98. Page number 98. So if they have, TPC has rejected me on merits on this day, 2nd March, my name is not there.
That's 2nd March, yes.
2nd March.
Rejected, correct?
Rejected on merits. Then, my lord, I need to have a gap, cooling period for another 1 year.
Yes.
So I will be eligible after, my lord,
2018. What happened?
Now, my contention is that, therefore, they are not rejecting me on merits, but whatever grounds available under as per the rules, they have called for the another TPC, review TPC. They call on 17. Lordship, kindly see page number 101. Just one month, 15 days, they call for the fresh review TPC. And in that TPC, my lord, held on 17, result was out on 18, and my name is there. My name is there. Therefore, this is under the contradictory to the rules. Therefore, my contention is, my lord, this TPC was absolutely a review TPC. They say that on merits I failed to secure in the first TPC, 2nd March. I failed to secure the marks in the interview. That is the ground. Well, that is not correct. If that is the case, I am not eligible for meeting for sitting of this TPC. So it is purely review, and if it is a review, the rule is very clear, my lord. The effect of review is that, my lord, I entitled for promotion with effect from the other my colleagues who got the promotion with effect from 1/1/2017. 16.
So they got effect from 1/1/16.
1/1/2016.
You lost out on
1/7/2000.
And this one is effect from 1/7/2000.
Yes. 1/7/2016, and the joining
and the other ones got 6 months advantage.
Yes, a 6-month advantage. So this I will continue, my lord, from 2017 onward, if I count to my retirement, 2026, 21 years, my lord, I'll be deprived of all these benefits.
That's it.
Yes, seriously.
Anything else?
And the last one, my lord. The last one. My lord, another limb of argument that I'll not go to other point. Yes. Now, I'll just clarify this. That the decision, second writ petition, the decision, they say that in the writ petition, in the affidavit file in the first writ petition, they took the plea.
Where's the first writ petition?
First writ petition, lordship, we are looking this. And in that affidavit, they have...
Where's the second writ petition?
Second writ petition is where it is in the second.
Then AG, where's Karkumar?
Well, yeah, they are also part. Now, in the first, when we filed this, the first writ petition, number 50, respondent has filed the affidavit. I'll not go to the details of the averment, but concisely, they have taken the plea that we did not give you the promotion with the financial effect from the day, from the date where you are getting promotion, but you'll get the financial benefit from the date of joining. It is because of the decision taken by the Board of Directors. Board of Directors held on 8 March 2017. That was the decision. They never say that the CMT has taken decision to deny it. Now we challenge that decision, the noting, and that noting is, my lord, I'll just come to the second writ petition, my lord. My lord, we come to page number 66 in the second writ petition.
One second. Yes, what do you have to show?
Secondary petition, my lord, page number 66. The impugned so-called decision or minutes or approval.
Page
number 66. My lord, this note sheet was prepared by General Manager, Mr. Parthakur.
Yes.
And I will just take to serial number 1 to save lordship time. The incumbents who are recommended by DPC for promotion with effect from...
No, but that's recorded in that order dated after promotion order 1/7/2016. It says that. It says that the promotion from effective 1/7/2016, but financial benefits will commence from the date of joining.
From the date of joining.
Yes.
And that is based on this minutes. On these minutes.
Okay.
Minutes. And he said it from the date of joining. Now the CMT, it says, my lord, at the bottom in the writing, that I discussed today, the 18th April 2017, with the Director Personnel, Director Technical, and telephonic discussion with the Government of India nominee in the board above. Proposals are, as elaborated, approved for implementation. So the day, my lord, the TPC was held on 17. If they have taken a decision prior to this, maybe, my lord, another case. But my TPC was held on 17, and result was out on 18. And on 18, my lord, he said this was a decision. This was the decision.
So backdated.
Oh, my lord, the decision. And he said telephonic discussion. Earlier argument, I've taken lordship attention to the Companies Act also. Any decision taken in the absence of the independent directors, it is not tenable in law. And here, my lord, no independent director also represented. And now, in this writ petition, second writ petition, they have filed the affidavit and they admitted that, yes, Board of Director, when they had the meeting on 8 April 2017, no agenda was there for this.
When they had the second meeting on? This meeting on 18th of April.
My lord. And first meeting is 8 April on the top. They said now in the affidavit they have admitted that there was no agenda for this issue. And second, my lord, minute also not there. We expressed the opinion, and now the affidavit they have changed. CMT has taken a decision to give financial benefits from the date of joining. Now, whereas the resolution said approval. Now, my last contention is, if they have Board of Directors taken a decision on 8 April and CMT approval on 18, may be correct. But if there is no decision taken on 8 April, the question of approval on 18 doesn't arise. Well, and 18 April, even if considered as a decision in absence of director, it is not independent director. It is not tenable. And the last one, my lord, I'll just refer to that longest duration when lordship asked me. That one, I'll just come to the rule once, and my lord, I'm ending up my argument, my lord. Page number 4 of the rules, my lord. Page number 4 of the rules.
Yes.
Page number 4. In the middle paragraph, may I just read, my lord? Annual performance appraisal report. In the middle report for any period of less than 3 months.
Where reading?
My lord, in the middle, my lord. Annual performance appraisal report for any period of less than 3 months in an appraisal year will not be taken into consideration for the purpose of promotion. However, where 2 or more reports are written in any appraisal year by reason of an employee being posted under different reporting, reviewing, accepting officers, a single rating for a year will be determined.
That's what the senior, that's what Mr. Jindal has said. Single rating will be given if there are 2 segments. Then single rating will be given by DPC when it assesses you for promotion.
But therefore, I took the instruction from my party also. The meaning of single rating, the practice in the NEPCO is that the longer duration, it means my single rating means longer duration. Right. And that was more revealing in the amended one. Amended one, may I just show? 2000. But the amended one of the rules is clarified. It's very provisional.
When was it amended?
Amended, my lord, in 2019.
This is a
different, but it is same rule but amended one, my lord. The flag one, lordship, kindly come to flag number 1. But
yes,
for a 6.43. Lordship court. 6 point.
No, you give me the memorandum of association.
I'm sorry. Anyway, I'll just refer. So I'll just give you back. I'll just give you. My lord, the flag one, my lord.
Once again.
At the bottom, last paragraph, it says, my lord, annual performance appraiser report for any period of less than 3 months in an appraiser year will not be taken into consideration for purpose of promotion. However, where 2 APARs are written in any appraiser year for reason of executive being posted under different reporting, reviewing, accepting officer, the Departmental Promotion Committee shall consider the rating of the APAR for the longer duration. When there are 3 more APARs, my lord, is not really related to our case. So it is very clear. That is the practices in the corporation. Therefore, the first APAR is for 3 months, for 14 days something, and the second APAR is, my lord, written by the CBO is nearly 8 months. So that longer duration prevails. Now I'll just cite the decision and I'll close my argument. That 1978 one is a C. The MHL, I will not repeat it, my lord, with highest respect to the view taken by my learned senior.
Regarding?
My lord, regarding the reason, substitution of reason. In the affidavit, learned senior has taken.
Again, you're citing Singil only now.
Oh, my lord. So I'll not repeat, my lord. But he has taken the view that that case is not applicable.
Yeah, what do you have to say?
Show
how it's applicable.
My lord. My lord. That is the contention of my learned senior that it is not applicable.
Yeah, okay.
My lord, with due respect, I take the contrary view that the reason, but the law laid down by the Apex Court is even applicable to corporation.
Which paragraph?
My lord, paragraph number 4. Para 8, my lord. Para 8.
This is how many?
Should be
para 8.
Should be my lord.
Page 417.
My lord. I will not repeat, my lord. And second one, by 2016. 2016 also. 2016 para 4. 2016 volume 1 ACC.
Oh, sorry, 2000?
2016 volume 1 ACC. By page 724, relevant para 4. It says that, my lord, the ground mentioned in the impugned order must be self-sustainable. Reason cannot be supplemented by affidavit by the respondents. In my case, my lord,
come again? Ground?
The grounds, my lord, the grounds or reason mentioned in or appear in the impugned order should be self-sustainable. Respondent cannot supplement the reason.
That is the point, on that point.
Yes, on that point.
Grounds given.
Yes.
In the order should be self-explanatory.
Self-sustainable. It cannot be replaced by the respondent in the affidavit. That CMT, not cheats and the approver. my lord, with regard to that. And other one, my lord, this 2007 volume 6
Yes.
2007 volume 6 SEC page number 524.
2007
6 SEC page 524 relevant paragraph 4.
Yes. Right.
Well, it talks about the.
If you're citing you, I have to again reply.
No. Last time also I have cited this one. I have cited
Only
already.
two judgments you cited on the last time.
Well, now this paragraph 4, my lord. May just remember. Learned Counsel for the State has submitted that grant of a retrospective benefit on promotion post cannot be given to the incumbent when he has not worked on the said post. Therefore, he is not entitled to any benefit on the promotional post from such and such. In support thereof, the Learned Counsel invited our attention to the decision of this court in such and such, my lord. Such, my lord. We have considered the decision cited on behalf of both the sides. So far as the situation with regard to monetary benefits,
You mean it's like case to case, and if you find that it's been deprived arbitrarily, then you will be entitled to whatever financial benefits from the date. Yes.
Therefore, in this context, my lord, whether this person was arbitrarily denied or not, because all the parts written by Verma accepted, and my one is excluded. So the arbitrariness is there. And the last citation, my lord, 2008, volume 8. Madam.
Yes, page.
Page number 725. Relevant para 17. And my lord, the Honorable Apex Court succinctly held this law. My lord, earlier occasion, our learned senior said that, my lord, the APAR securing very good or good is not required to communicate. But it is very clear, my lord. Para 17, my lord, Lordship, kindly come. In short paragraph.
No, the Dev Dutt is a famous case.
My lord, a famous case. Even Lordship has held in division bench also. It is mandatory. Well, even very good also.
No, that is
well, that is the law.
Except for military forces.
Yes, except military forces. For my humble and respectful submission is, my lord, the injured action of respondent is maybe strike down and with prayer will be granted.
You give bullet points. Since you argued for so many days, I can't keep track of arguments mentally.
So I'll just take 5 minutes time in view of the fact that so for the second APR,
the bullet points.
APR is concerned.
Ready? Yeah, bullet points ready?
Bullet points, man.
Yeah, Mr. Gentle, your bullet points ready?
Bullet points. Short one.
Lordship, in view of the submission made by my friend with regard to the second APR, it becomes necessary to clarify the second part. Lordship will just come to the second part of the APR written by CVO. Then I will take to your Lordship the relevant rule. Now,
1 second. 1. First part is okay. Now you're coming back to that.
That's remark of the CMD.
Accepted the marks awarded by reporting officer.
That's what your Lordship. This requires clarification. Now, so far, reporting officer is concerned. He has given very good, and CVO has changed from very good to
outstanding.
APR is sent by CVO to the CMD. CMD, what he says, accepted the mark awarded by the reporting officer, meaning thereby he has accepted the remark of very good.
Yes.
He has not accepted the remark of CVO. Reasoning he is giving, awarded by the reporting officer in view of the All India Service Performance Rules 2007. Your Lordship, first I will take Your Lordship to CVC circular. What does the CVC circular say about this? Page 40 of the written writ petition.
Become unending now. Yes. Page
40.
40.
40 of the writ petition.
Yes.
Then come to Your Lordship, relevant portion for page 41, subclause 2.
Yes.
The ACR of personnel working in the Vigilance Department will be written by the CVO and reviewed by appropriate authority prescribed under the relevant conduct rules. The remark in review shall be perused by the CVO, and in case he has reservation about the comments made under the review, he shall take it up with the Chief Executive HOD to resolve the issue. In case he is unable to do this, he shall report the matter to the commissions who will intercede in the matter suitably. This is the, Your Lordship, relevant provisions. Now, in this case, what has happened? That CMD has given certain remark. He says accepted the marks given by the reporting officer in view of the provisions contained. Now, these remarks as per this require to be seen. Now, the person who has reviewed the reporting was not in the station, and he has written the ACR of the persons when he has already relinquished or vacated the office of CVO. To this effect, that what the rule says in such a situations, supposing a reviewing authority transfers, rule says that before he hands over the charge, he should complete the ACR of the persons working under him. And supposing he is unable to do for one or the other regions, then he has to do within a period of 1 month from the date when he relinquished the office.
That post. Yeah.
And if it is not done, that review will be of no consequence. It will be unenforceable for all purpose. That is the rule, what it says, Your Lordship. Then Your Lordship will just see the 2007.
That is quite vague also. The ECR of personnel working in the Vigilance Department will be written by CVO. Means he'll be the reporting authority? Or what's his position? And reviewed by appropriate authority. Now, who's the reviewing authority? Here in this APR we've shown is reporting officer, someone else. Reviewing is done by the CVO.
Review is done by CVO.
That very good outstanding.
Yes.
But then the CMD now is he functioning accepting authority, or they are, or he's not, or it's a
no. Your Lordship, here what the circular says, written by the CVO and reviewed by appropriate authority prescribed under the relevant conduct rules.
Yes.
Reviewing authority is also CVO under the related conduct rules.
Okay.
And after that, the remarks in review shall be perused by the CVO, and in case he has a reservation about the comments made under the review, he shall take it up with the Chief Executive HOD. My point, what point I am going to make it, Your Lordship, that that after the CVO has relinquished the office, he has not written any ACR of the writ petitioners. Neither he has written at the time when he was transferred, nor he has written at the time within the stipulated period of 1 month. He has written after 6 months of relinquish the.
So he becomes functus officio.
Yes, he becomes functus officio.
That means
It is for the region, Your Lordship.
Whatever he marks is written there will become non-est.
Non-est.
But then
unenforceable. Unenforceable. And to that effect, Your Lordship, I will just point out.
Getting more and more complicated.
Because Your Lordship, here, this remark was not easily readable to me at that time when I made this
submission. It's not even readable to me also.
But now it is clear. He made it little more clear by showing that it was downgraded from outstanding to very good. Then how it was done, I have to read it carefully. I found that CMD has accepted only the marking of
reporting
officers. And he said...
So your stance is that the CVO is not reporting, it's only the reviewing authority here.
Yes, reviewing authority things were taken into consideration.
No, he's a reviewing authority. He is a reviewing authority. The reporting authority is different, reviewing is different, CVO, and accepting is the CMD.
CMD.
That's what he's saying.
Yes.
Okay.
And if the CVO is not satisfied with the remark whatever the CMD gives, then he can take up to the CVC. He can take up the CVC. But in the instant case, Your Lordship, what has happened?
No, it says remarks on review shall be pursued to, and in case of reservations about the comments made under the review, he shall take it up with the chief executive stroke HOD. HOD. This is not what he's saying. Now he's saying that he's not taking with the CVC. CVC is not in the picture. He said he shall take a chief executive HOD to resolve the issue.
He's the CMD only then. Actually, if it is so.
Exactly.
Yes.
So he has no reservations. He's given his grading.
Yes. Right. No, the point here is this, Your Lordship, that at the relevant time he was not there at all. He ought not to have given any marking.
Okay, great.
Any marking. Yeah. Now, Your Lordship will see, come to page 42 of my affidavit.
42?
42.
Yeah. 50 of this 50 WC 50.
Yes, Lordship. First.
40.
Page 42.
42. Okay.
Yes.
Yes.
Your Lordship will come to the relevant page 43.
Yes.
Sub-rule 2 of Rule 5. Sub-rule 2 of Rule 5. Rule 5 performance appraisal report. Come to sub-rule 2. Sub-rule 2.
Well, no, where? For page 43.
43.
Sorry.
Page 43. Rule 5, under this, I am reading sub-rule 2.
Okay.
Subject to the provision of sub-rule 4, a performance appraisal report shall also be written when either the reporting or reviewing authority or the member of the service reported upon relinquished charge of the post, and in such a case, it shall be written at the time of relinquishment or ordinarily within 1 month.
So there's no time prescribed. Ordinarily means ideally do it in 1 month. That doesn't mean it's non-est, the remarks made by the CVO.
No, ordinary cannot, 1 month time.
It's not mandatory. See, I say like, okay, this project ordinarily should be completed within 1 month and the contractor takes 1 year.
Yes.
Doesn't mean that it's,
no, ordinarily, Your Honor, cannot be extended for an indefinite period.
Ordinarily 1 month. Ordinarily
1 month, it may be double, 2 months.
No, then we're going interpreting something else. Yes. But
Then
we will not accept your contention that it become non-est, that 6 months. That means, yeah, I thought it was mandatory that suppose at the time relinquishment of the post,
Lordship,
within mandatorily, we have to write it within 1 month.
44.
Okay.
44. Sub-rule 7. Sub-rule 7. Notwithstanding anything contained in sub-rule 1, 2, 4 and 5, it shall not be competent for the reporting authority, reviewing authority or accepting authority to write a performance appraisal report after he demits office where the authority writing the performance appraisal report is not a government servant. Here, Your Lordship, this rule applies that in case he demits the office, he is not competent. Then come to Your Lordship, Rule 6.
Where the authority writing the performance is not a government servant. Now, CVO is not a government servant.
CVO is a government servant.
So this is not applicable.
Yes, come to Your Lordship then 6.4.
Okay.
6.4.
6. Next page.
Rule 6, sub-rule 4.
Okay.
Notwithstanding anything contained in sub-rule 1 and 2, it shall not be competent for the reviewing authority or the accepting authority to review any such performance appraisal report, where the authority reviewing the performance appraisal report is a government servant, where the authority reviewing the performance appraisal report is a government servant. In this case, he is a government servant. After 1 month of his retirement from service, in other cases, after 1 month of the date of which he demits the office.
Okay, you might have a point here.
Yes. So, Your Lordship, this ACR, whatever is written by the CVO,
cannot be relied upon.
And was not rightly relied upon by the DPC.
So that's why, but...
my learned friend has also given one letter during the course of the hearing. He says that for others it was accepted, for me it was not accepted. Your Lordship, this is not in the pleading, Your Lordship. The letter which he has given, it doesn't contain his name also, that his ACR was sent by this letter. Now, whether it was accepted or it was not accepted, I am not in a position to make any submission whether these cases falls under the promotional category or not. So, no inference can be drawn on this letter, Your Lordship. I close my argument, Your Lordship. If I feel necessary, I will just give a note.
Yes, you have to give the note.
Right.
The court's totally lost because arguments have gone from
different
all over the planet. Yes.
Right.
Yes, this is the matter after 1 week to enable the parties to submit the bullet points.
Yes.
You submit better bullet points then?
Yes, yes.
It's gone on long enough, this matter.
I realize, Lordship. His cases are like that only. It's so taxing.
A bit technical as all, yes. It's taxing for the lawyers to argue it because, and it's taxing for the court also, because there's so many, it's not too much trivia, like they say, like playing a role.
Especially this APR business is ACR is very complicated.
Very complicated.
Aliullah.
Much of
yes. After 1 week. Thank you.
Item 13. 13.
My Lord.
Yes, Mr. Pathak.
My lord, this pertains to, my lord, discriminatory treatment, my lord, meted out to this petitioner. This is treatment, my lord.
Treatment.
Okay. My lord, the discrimination that we allege basically is that she had some visual defect, my lord, which she had corrected by LASIK surgery.
Okay.
And
what defect?
some visual acuity, my lord, myopia.
Visual
Myopia, my lord.
She had LASIK
Which
surgery, my lord.
she had done LASIK surgery, and our allegation is basically, my lord, where the doctors, my lord, she was, my lord, seeking appointment as a nurse, whereas the doctors, my lord, the Group A officers are permitted such corrections.
Yes.
My lord, the nurses who work under them, they are not, my lord, permitted such correction, my lord. That is what we allege, my lord.
Is it true? Dr.
My lord, that
Yes? Yes. Where is that where you've been rejected or discriminatory treated? Yes.
my lord. There is a medical board proceeding, my lord. In fact, I would pray, my lord, if it is better if, my lord, this is taken up in physical hearing. Today I could not come because a lot of papers have to be referred to, my lord. The medical board finding is of 8/6/2015 during the selection.
Yes. Mr. Pathak prays that the matter be taken up by physical mode as visual mode as he could not come today. Yes. Prayers allowed? Yes, after 2 weeks, yes. You come, we finish it out.
14.
Yes.
14.
My lord, in this case, I am raising that preliminary objection, my lord, regarding the maintainability of this case, my lord. This is regarding the respondent. Herein, my lord, respondent number 10, who was the nominee of her husband in the service book, my lord.
Respondent number 10.
Respondent number 10.
She is not party here. I mean, she's not appeared.
My lord,
Who's appears number 10?
I am appearing for respondent number 10, my lord.
Okay,
I am
sorry.
raising that objection, my lord.
Yes. What objection you raising?
No, my lord, she was the nominee in the service record, and thereafter, my lord, after the death of the husband, the pensionary benefits and everything was released to her. Now, my lord, the petitioner herein claims to be the wife, and on the basis, my lord, they want the pensionary benefit to be recovered from her, and the entire order which has been passed by the releasing the pensionary benefit should be set aside. Now, my lord, these are all disputed question of facts, my lord, which cannot be entertained under this proceeding.
Where has it been ordered?
The facts first.
And
yes.
Another one submission, my lord, the petitioner number 2 herein, my lord.
Yes.
Now, she herself has given a letter in the name of respondent number 10 that she does not have any problem, any issue if respondent number 10 is
drawing all the benefits.
Right.
Yes.
And surprisingly, my lord, she comes in your writ petitions, my lord, being a respondent, being a petitioner number 2, and files this case, my lord. And all the annexures, my lord, whatever has been enclosed along with the writ petition, my lord, these are all, my lord, which are yet to be proved, my lord.
So I may take your lordships to the facts first.
Yes, please.
Lordship, I straight away come to page 37 of the writ petition. Page 37, annexure 1. So here, my lord, the petitioner's husband, since deceased, was appointed as the armed branch constable, my lord.
Annexure 1 is some certificate of marriage.
Lordship, I'm just giving a background. The petitioner's husband, my lord, was posted as the armed branch constable in the Meghalaya police, It's on 15th of June 1983, my lord, and he unfortunately died in the year 2013. Now, my lord, the petitioner's claim here is that she is the first wife. Lordship may have Annexure 1, page 37, my lord. This is the marriage certificate. The typed copy is in the next page, my lord, page 38. Lordship, the place and date of marriage is listed on the stated in the top, my lord. Pindengre, 1994, my lord.
Yes.
The name of the bridegroom, my lord, is the deceased husband, and the name of the bride is the petitioner, lordship. This has been issued by the church, my lord. So they were married, my lord, on 19th of January 1994, my lord, under the Christian marriage. Thereafter, lordship will find Annexure 2 in series, my lord, are the 4 children born out of the said wedlock, my lord. Page 40 is the first type copy of the birth certificate, my lord. The name of the father.
When did he die? 2013.
2013, 14th of August, my lord.
Okay.
So the first one, my lord, at page 40.
Okay.
Is the daughter, my lord, born in 1995 to the deceased husband and the petitioner, my lord. Thereafter, my lord, at page 42 is the son, my lord, born in 1996. Page 42 is the type copy. Again, my lord, to the petitioner and the deceased husband. Then page 44, my lord, is another son, another daughter, lordship. She was born in 1994.
How is it possible?
I am married.
How is it possible if 95, then the second one is 96, the third one is born 94?
They are not arranged in the order.
Same father?
Same father, same mother, my lord. 1994 is the third, my lord, child. And page 46, lordship, is the fourth child, my lord. Born in 1997, my lord. Page 46.
So within 2 years, 4 children.
What?
25, 11, 95 to 26, 11, 97, you got 4 children.
Not 4 children. 94 to 97, 4 children.
No, the date of birth of the first child, 25 and 95, right?
The first one, my lord, is 23/4/1994, which is at page 44.
First one is 94.
Yes, lord. I'm sorry.
Okay, 94 to 97, okay.
Yes, lord. So 4 children, my lord. And so, my lord, the husband of the petitioner died, my lord, and on 14th of August 2013, lordship will have the death certificate, my lord, at page 51, lordship.
Yes.
Page 51, my lord, is the death certificate.
Yes.
The date of that is 14th of August 2013.
Yes.
Now, my lord, before that, lordship, I would like to take your lordship to page 49, my lord.
Yes.
Page 49, my lord, is not very legible. The type copy is at page 50, my lord. Essentially, this is a certificate by the Rongba Shnong, my lord.
Okay.
Certifying
Next.
that I am the wife. So,
Yes.
on the basis of this certificate, my lord, an amount of 3,000 was paid to me by the police reserve as maintenance, my lord, for a
So you killed your husband?
lordship.
Oh.
No. This was before his death, my lord.
What certificate is this?
This is a certificate by the headman saying that
This fellow beat you up.
Lordship, basically he is recommending for maintenance, my lord. That there was some dispute between them.
Oh, okay. No, that means you were not staying. You were not. The husband was staying with you any longer.
No, he was.
Then why are you claiming for maintenance then?
No, there was some dispute with some fight and all. So the headman recommended that they will maintain, and they had given some 3,000 rupees. So that is besides the point, lordship.
So you also feel the factum that they were husband and wife.
Yes, and she was receiving some amount.
Right.
So, my lord, these similar certificates like the death certificate were issued by the Sardar and the my lord, the church, where the funeral was.
Yes.
All that.
Come to the main point.
Lordship, on at page 56, my lord, the petition number 2, who is the sister, page 56, my lord,
Yes.
filed at RTI. asking for inter alia the debts and securities of the deceased husband of the petitioner number 1, my lord. Thereafter, my lord, certain internal communications were made as well as a representation was filed, and finally the reply came on 30th of April at page 61, lordship. Page 61 is the reply to the RTI, my lord.
Yes.
Lordship, what they essentially say here is that the entire pensionary benefits have been processed in favor of the respondent number 10 and has been disbursed to her, my lord. That is at serial 2. On receipt of the government instruction dated so and so, pension has been processed in favor of the respondent 10 and this has been, my lord, withdrawn by her.
So, it was withdrawn on the basis of which document? Succession certificate?
Letter of, my lord, 13/6/2014.
Which letter is that?
That they have not enclosed, my lord, but we have recorded.
No, I mean, like, there was no succession certificate,
No,
I think, given
I'll
then.
come to that, lordship. Very interestingly, in the same RTI, they say, my lord, that I have also asked that how have they claimed the nomination. They replied that she was the nominee. Nominee Srimati so and so is
Where is that?
That is at page, the next page, my lord, 62, 3B3, mentioned as.
Oh yes,
System of
okay,
claiming.
right.
The nominee is entitled. Thereafter, being aggrieved, I have again filed a RTI, my lord, at page 64.
Yes.
Asking that what application, what document has been submitted to claim that, my lord. In reply to that, lordship will find at page 66, lordship.
Yes.
They say, my lord, nominee details is number 1, respondent number 10 in bracket wife, number 2 is stated to be the daughter, and number 3 is a nephew. And application is enclosed, my lord. Document proof is an affidavit.
Yes.
4th of June. And any other document of the birth certificates. Lordship may kindly
What is
come-
this? What is this? Okay, nomination. Kisila Mopa. Okay, wife, 39 years. Okay, yes.
So that they have enclosed at page 67.
Right.
The
Continue.
form.
Yes.
However, there's no date.
Two daughters and nephew.
Lordship. Now, very interestingly, my lord, kindly have page 71 is the affidavit which was filed before the authority.
Yes.
Lordship, the first paragraph is a general development. Second line, my lord, I am the wife of late so and so, that out of the said wedlock of my husband, no issue were born to us.
Yes.
This affidavit is to produce before the constitutional authority for declaring my wedlock. When were they married also is not stated, my lord.
Yeah,
When, how? So this was the only document which was there before them. Admittedly, my lord, there was no issue born out of the wedlock. And these persons who have been named in the nominee, the children, are not children of the person who has died, lordship. Lordship will have that at Annex 18, page 73.
It's okay. I mean, he can adopt the children or they can be
I'm
stepchildren.
not
That is not a.
I'm not saying that, but that is the position, my lord. That name of the father is not the name of the deceased employee. It's one P.S. Swear.
It doesn't matter.
So thereafter.
You're really concerned about the respondent number 10 and you. That's all.
Lordship, yes. So at page 76, my lord, I have filed an objection.
Yes. So what happened after I rejected it?
No, yes, and again I have filed another objection at page 77.
Yes.
They have replied, my lord, by a letter of 12th of June at page 79.
Yes.
Lordship, what they have said is that pension has been settled in favor of the respondent 10. And this has already been paid, my lord.
To the eldest surviving wife.
They have given that reasoning in the last page of my petition, page 80, my lord. This is an interdepartmental communication. What they say, my lord, is that I am directed to refer the letter cited above in connection with the family pension claimed by respondent number 10.
Okay, Mr. How do you expect this court to go into this aspect?
Lordship,
Now how can we take cognizance of that? Whatever marriage certificates before, birth certificates can be fine. Maybe you might be cohabiting.
Here, my lord,
What is
the
simple
rule.
case?
The rule says that the pension is to be given to the eldest surviving wife.
Yes.
Now, my lord, there is admittedly a claim and a counterclaim, which is evident from the letter. They say, my lord, that the respondent number 10 is the eldest wife, so we should give it to her. The entire.
So who's elder?
The entire.
Who's elder?
No, elder, my lord. Elder is in with reference to the date of the marriage.
No. Who's elder? He said married when to him with this affidavit. What did he say? When he said we got married when?
Not mentioned, my lord, when.
Exactly. So who's going to say who's eldest? You're elder or she's elder?
So exactly why, my lord, the department should not have sanctioned it.
No. The question that they came first, they were the nominees. See, what is the first claim on right? They are the nominees, written nominees in the service book. Okay.
Which is
That is the only, that is a substantive, like, records which are present before the. Now, service book, when it's sign a nominee, the person knows very well who's nominating. Correct?
Yes.
So he's given her name. Now, just look at your position. Where are you? You got married 94 or 93, what doesn't matter. But what other document? You're not the nominee, number one. So how will you assert your case here? When then you have to file a suit.
No, my lord, my case is that.
See, now that is a matter of evidence on that medical certificate. And who's the eldest surviving wife? Who got married first? Now he'll say that I married your husband first.
Date, my lord.
Exactly.
Just
now he can.
I come and say, my lord, that.
How do you expect this court rather to say fine, in view of the marriage certificate dated 1993 and view Rule 48 of the Meghalaya Civil Service Pension Rules, that the petitioner is hereby, recognized as the eldest surviving wife, and so all the pension benefits go to her. Can the kind of manuals be issued?
My lord, if that is the case, then both the parties may be relegated to the competent court because admittedly no one has a succession certificate, my lord. On a basis of an affidavit.
Why should we relegate this? It's for you to establish your case. You're on a back foot.
On a basis of an affidavit which does not even state when they are married.
Take down.
How can they?
Anything to say? State.
And the rule, my lord, says eldest surviving wife.
The respondent is a nominee one.
That is the only.
And we deny the fact that she is the wife also.
To deny, they have to establish
And
that they are the wife first.
my lord.
Burdens on whom, Mr. Dev?
My burden, my lord, I have
burdens on whom?
burden. My registered marriage certificate is there.
It's a registered marriage certificate.
From the church, my lord. I'm sorry.
Yeah.
From the church.
So burdens on whom?
No. In my humble submission, my lord, just by saying that it is a disputed question of fact and denying the wife, that
no. That it's not a question of them denying saying disputed question of fact. The thing that's in their favor is what? Which is overwhelmingly favor is the fact that respondent number 10 is the nominee in the service records of the deceased employee.
Yes,
Simple as that.
That's the only thing, but that is not the.
That's the only thing. That's the main thing.
No, my lord. They say that.
Why don't you file for succession then?
No, succession, my lord. I have the registered certificate. Everything.
Then why don't you go for succession then?
No, succession, my lord.
Where when your husband died?
Yes, my lord.
He died
birth
with me,
certificate
my
is
lord.
no, that is
Even
not
the my lord death certificate which they have enclosed, that is my address, my lord.
My lord.
Were you aware when he died?
Yes, my lord. I have those all, my lord. There is nothing. If my learned senior can say, my lord, when they were married.
Why should he say when they were married?
But then tomorrow, my lord, I can simply come and say, I'm not the wife, he's the wife. At least they should establish the dispute.
The petitioner before this court.
I'll pray, my lord, that let the pensionary benefits further release may not be there, my lord. Both the parties can approach the competent court and.
Yes, okay. The writ petition before this court.
And only because of nomination, my lord, if my statutory
praying for directions to set aside order dated 13/6/2014, whereby the pensionary benefits of a deceased employee, namely one Morris Marangar, has been released in favor of respondent number 10. Stop. Next, the pleaded case of the petitioner is that she is the legally wedded wife of the deceased employee. Deceased wife of this is the legally married wife of this employee who entered into matrimony, which is evidenced by the certificate dated. You got married in 94, but certificate is 2011.
At least I have some certificate.
I like that. I like your positivity. Yes. Even children were born, 4 children born in a space of 3 years also. It's anyway. We're not looking at that also. Come no?
The facts, no, I cannot.
These are the facts, correct. Matrimony on 19/1/1994, which is evidenced by a marriage certificate dated 22/1/2011, issued by a certain Saint Peter the Apostle Church and signed by the parish priest. It is the further case that the respondent number 10. You see, she's not married also.
No, there's nothing to
Yes,
say.
number 10 was never legally married to the deceased employee, nor were you ever divorced from, nor was the petitioner ever divorced from the said employee. So, the grievance, the grievance, therefore, or the prayers, therefore, for directions to issue to the respondents to pay the retirement benefits to the writ petitioner, and also for directions to recover the amounts already drawn. Stop. Next paragraph. Should we record its submission or not necessary? It's okay. Mr. S. Deb, the counsel petitioner, has vehemently argued that there are no materials to substantiate the fact that the respondent number 10 is the eldest surviving wife of the deceased employee. To have been granted the family pension under Rule 48 of the Meghalaya Civil Services Pension Rules 1983, and that in spite of repeated representations, the respondents have not considered the case of the writ petitioner. Stop. He lastly submits that just on the basis of a nomination, as it appears in service records, the respondents could not have released the said benefits. Now, next paragraph. Ms. Ensign Con, Learned Counsel, number 10, has at the outset submitted that the petitioner has come before this court and raised disputed facts, as even a marriage certificate is yet to be proven as to its authenticity, for any reliance to be placed upon the same. He further submits that the respondents, the deceased employee, having nominated the respondent number 10, there was no reason for the official respondents to disregard entries made in the service book, and as such, in accordance with law, the retirement benefits have been released to respondent number 10. So, Mr. K.P. Prasad, anything to say? Nothing.
The respondent number, private respondent is the nominee.
Yes.
That's what the record.
Next, Mr. Kibaracharji concurs support submissions of the counsel for Midden and submits that as per the records, it is respondent number 10 who is the rightful nominee to receive the retirement benefits. So, easy nothing.
Lordship, in my affidavit from annexure 1 to 5, Lordship, these are the prescribed forms for pensionary benefits and other pension benefits, Lordship. So here also all the nomination, all the nominee, the name of Kesila Mengap has been
Yes,
there, Lordship, been mentioned.
Mr. K. Karmakran, on behalf of the respondent number 78 and 9, that is the Accountant General, has drawn attention of the court to the annexures appended to the affidavit, annexures 1 to 5 appended to affidavit, and submits that as per due procedure and the documents available. It is the respondent number 10 who fulfills all the requirements, and as such, the pensions were released to her. So, next paragraph. Having heard the counsel for the parties, it appears that from the materials available record, this court it will not be in position to conclusively discern as to whether the petitioner or the respondent number 10 is the eldest surviving wife. Coupled with this is a fact that the service records of the deceased employee have clearly nominated the respondent number 10 as noted number 10 to receive the terminal benefits. The writ petitioner has not been able to show as to the writ petition. Last line, sorry.
This fact that the service record deceased employees clearly nominated the respondent number 10 and has received their benefits.
Yes. There are the respondents, it appears, have proceeded strictly on the basis of available materials, which is on the basis of materials which have created a right on behalf of Merton, in as much as the service book and the entries therein are the only source of information for employers to determine the rights of deceased employees. Next, as the writ petitioner has been able to make out a case for interference, the writ petition is dismissed. However, it shall be a bar for the writ petitioner to seek alternate civil remedy in accordance with law. Matter stands as well.
Very unfortunate ones.
It happens all the time.
Police department, it appears to have.
See, it's not that. It's policemen, when they go all over the place, they do all mischief. Yes.
So much of
20.
Yes, Mr. Patak.
This was relating to compulsory retirement, my lord. The age of completion of 30 years of service. Also, a series of petitions have already been decided in this regard. And ultimately, my lord, these people, my lord, this 2015-16 people who retire, one batch, my lord, the writ appeal has been remanded back and the writ appeal has been allowed.
Writ appeal has been allowed?
No, the writ appeal was remanded back and the writ petition has been allowed, my lord.
By which court?
By this court only, my lord. But then we, unfortunately, my lord, we could not be, my lord, hesitating in that particular writ appeal. So the only issue now is that, my lord, whether that judgment.
Out of this bench?
No, my lord, by Justice Dinglo. The issue, my lord, is now that whether this would be a judgment in rem and also cover us.
So where's the writ appeal judgment?
The writ appeal, my lord, we were not a party, my lord.
No, writ appeal judgment demanding this case.
Annexure 6, my lord.
Writ appeal?
Yes, my lord.
Which trade is this?
They're across the trades, my lord. My lord, what happened here?
1 second. Annexure 6.
My lord.
Page?
22, my lord. 22.
Annexure 6, page 22.
Division benches order, my lord. Division benches order is at page. The operative part is at page 111, my lord. 111.
One. Okay. Yes. 111 is a single bench order.
No, my lord.
Oh, one operative part. Oh, sorry. Yes.
The last part, conclusion.
Yeah. Yes.
What happened here, my lord? In Assam Rifles, my lord, under Rule 48 of the CCS rules, my lord, a service review was carried out on completion of 30 years of service, my lord. Whether he is fit to be continued in service or he should be compulsorily retired.
Yes.
Or Deadwood are sought to be retired under that scheme, my lord.
The shape, this one?
Shape and here what happened, my lord? Medical category, because many become obese, high blood pressure, and all those kind of things step in, my lord. So those ways sought to be sorted out, my lord, and compulsory retired under that scheme. So when many of them they were compulsory retirement, they came before this honorable court, my lord. The learned single judge, their plea was that, my lord, service review can only be on the basis of ACR and other things, my lord, and character and integrity of an employee. Low medical category is not a ground to, because for low medical category under the Assam Rifles Act there is a specific laws that if somebody Rule 17 that for how to deal with the low medical category people, my lord. So the service review cannot be resorted to weed out those low medical category people, my lord. But the learned single judge Justice Sen at that point of time came to a conclusion that health is or low medical category is also they are unfit, cannot be retained in service. So now the 8 petitioners before your lordship in this matter, my lord, they also challenged their compulsory retirement that point of time. All those petitions, around 70-80 petitions were dismissed by Justice Sen, my lord, by a common single order, my lord. Now only some of them they preferred an appeal against the Justice Sen's order, my lord. Out of these 8 petitioners here, 7 never preferred any appeal. So that judgment is binding on them.
No, the thing is that now 80 petitions were before single bench.
My lord.
Then after that,
Appeal
it all
was
dismissed. Then how many went before the division bench?
Only 21 went on appeal.
21 petitions. Okay, fine.
So division bench of Justice Maheshwari
remanded the matter.
Remanded back the matter to learned single judge, because in the meantime Guwahati High Court and other High Court took the different view from the view taken by Justice Sen, my lord.
Okay.
Ultimately, the matter was taken up by Justice Dindo, my lord, and in the similar line, order was passed that Rule 48 cannot be resorted for dealing with the low medical category people. They can start proceedings under Rule 17.
Now, how do you say will not apply to them?
My lord, they were before the single judge. Justice Sen's order is binding on them. They never preferred an appeal. That is our case, my lord. Because the division bench's order is only qua petitioners, my lord.
Yes, where does it say that?
111, my lord.
111 says so, my lord.
It says only the petitioners. Oh. When we retired? Long time ago.
My conclusion, if I may just point, it's a long time, 2015-16, my lord.
Oh.
My conclusion, if page 111, my lord, it says, accordingly and in view of the above, these appeals stand allowed to the extent indicated. The impugned orders where the petitioners' appellants are set aside and the related writ petitions stand restored for consideration. So 7 of the petitioners, my lord, they were not before the appellate court. So
they were there before the single bench at that point of time. No, but the thing is that why would operate judgment in rem if it's a judgment on law?
But the division bench itself says, my lord, for the petitioners.
So what does Mr. Pathak have to say about that?
And that is one, my lord. The 8th petitioner, my lord, in this case was not before either before the single bench. His first time he's challenging that order now, my lord, after almost 8 years now, 7 years.
Yes.
But we have not specifically challenged anything because the order I knew, my lord, that was passed earlier in the single judge, my lord, had come to a particular conclusion. But then since the law has been now interpreted and laid down differently.
Hasn't been appealed against? The single
no,
bench
this
order?
No, yes.
Why?
In fact, rather, my lord, what had happened,
because
my lord
matter went up to Supreme Court and there are orders from Manipur High Court also, my lord. So
Annexure 9 and 10, my lord, would see.
Where's the other High Court's order, different bench? 9 and 10.
Yeah, I have not analyzed them, my lord. But then Guwahati High Court orders are also there. Annexure 9 and 10, my lord, subsequently what had happened is that in view of the several judgments that went against this retirement under Rule 48, Assam Rifle discontinued this policy of retirement under Rule 48.
Yes. But this is dated September 21.
And 8 November 2021.
So you resort only to Rule 26.
My lord. So
but
we are,
my lord,
as per this, my lord, we have to be given an option now. If we want to come back and if we can qualify medically, we are to be taken back. Otherwise, we go, of course, my lord. So that option has now given to us.
This order came on 6th September 2021, my lord, and it on page 118, my lord, the last paragraph, it says, the policy of retiring the low medical category persons under the CCS be discontinued forthwith, and henceforth Rule 26 AR will be followed. So their case was of 2015-16. From 21 onwards, my lord, these new policies come. So either they resort to the order of the learned single judge, or they can resort to, in both cases, my lord, they are, in my humble submission, they will not succeed, my lord.
Henceforth.
Res judicata will squarely apply to them, my lord. Res judicata will apply to them, my lord.
That is what he's saying.
My lord.
No, but then like what will be your reliefs now? Back wages?
My lord. The relief, no, back wages of course will not be entitled to, my lord. We are saying that since this entire policy has been discontinued and have been held to be wrong, my lord, by different courts, we are saying that, my lord, we are to be given an option of, my lord, coming back to service. And if we qualify, my lord, yes, of course, it will be subject to, my lord, other medical
the thing
tests
is
and
that
other.
Mr. Pathak, you retired too long ago.
My lord. But in this other writ petitioners also, my lord, my colleagues, my lord, who went in appeal, they got the chance, my lord.
2015, 16 they retired, my lord. 2015 and 16. Now after
I think they have to go to division bench.
after almost 8 years, my lord.
That's what, 8 years.
They're out of training, out of active service, my lord. To reinstate them at this stage, my lord.
Yes. Okay, take
You know,
down.
when it's, Indian Service Order says that, my lord, you come back, then there will be no backages, and of course, subject to some level can still proceed against you, subject to.
What are your ages now?
Well, many of them must have attained
People will be
retirement, my lord.
50s, my lord. They will be in their 50s, my lord.
Because the exercise was carried out when they were 55 years, my lord. So now, in my humble submission, I can file an affidavit to that effect, my lord. But it's
No, because Mr. Pathak, one thing is that even to direct for reconsideration, also it has to be on certain set. I mean, only thing is that the court understands your difficulty is that other similarly situated people who gone for appeal, they were given a benefit, I think, of back wages and so on. And that's the only thing. The only thing that goes against you is that number one, you didn't appeal. Number two, that the division bench judgments applies only to people who didn't appeal. Number three is that the delay you filed this repetition in 2021, and that judgment, the division bench was given in 2017, and other points you retired in 15-16. What kind of reliefs? You can't expect reliefs, and fifth, and the other point is that policy document to 2021. It can't be made to apply retrospectively, because it's clearly written there. It's going to be prospective. So take your call.
My lord, some other repetitions, my lord, from Guwahati High Court that orders I
Can you produce some authorities? Then we'll consider. Otherwise, we'll just put it off to your detriment.
My lord, I'll find a short, my lord, summary of arguments, my lord.
No need for summary arguments. Only that yes, you have to try to bring some authorities. Yes.
My lord.
Yes.
That is all.
After hearing at some length, Mr. B. Pathak, please matter to present some authority in support of his case. Res judicata. Yes. List after 2-8.
23. 23.
23 is my
waiting for some matter.
Yes.
Yes. Mr. Pathak.
23 is not retirement on 30 years of service. Here, my lord, the issue is ACR though. My ACR for 2018-19, my lord, was not communicated, my lord. Sorry, 1920 was not communicated.
But this is not a simplicity case of ACR, my lord. My lord, the petitioner was sent on deputation to NSG, my lord, for a certain duration of time.
Yeah.
There he was caught red-handed, accepting bribes and some misappropriation, my lord. And then he was charged and tried by the NSG for that offence, and penalty was imposed on him. So, my lord, in these circumstances, this is not a case of simple non-communication of ACR, my lord. So because of that penalty, my lord, the ACR was downgraded for that particular year.
But does not communicate to him. But he's aware of the infractions.
But he's fully aware, my lord. He participated in the proceedings, my lord.
Which proceeding?
NSG proceedings, my lord.
Of course, but then his downgrading, was it communicated to him?
It was.
No,
it was not communicated.
Not.
Then you communicate and reconsider. And these facts will come that time, since you already faced the proceedings. So sorry.
My lord. In fact, they did not say so in my retirement order, my lord. They did not say so that because of your doubt in integrity, we are retired. They simply said
orders.
I'll
dispose of it.
My lord.
Next, yes.
26.
My lord, this is the nectar matter, my lord. After permanently.
Where's the other matters? The other
There are
matters.
Two more matters, my lord. Total 3 matters are there.
They are your cases only.
No, I think Mr.
One Mr.
Paul is
Mahanta,
appealing.
one Mr. Mahanta,
Oh,
and one
she's
Mr.
there.
Paul.
They ready with the matter.
Those are not listed. Those are listed on 26th. 26th of this month, my lord. But the pleadings are not complete in those matters, my lord. Only rejoinder is left. So
In our case, it is complete.
We have listed together.
it can be disposed by common order, my lord. Facts and everything is the same. My lord.
How can you, after recruitment, you just, you know, a peculiar case.
They haven't done. There are some lapses.
Yes,
What
okay.
lapses also there are.
DGS, that two other similar and identical matters are pending for this court, wherein the pleadings are yet to be completed. He prays that on completion of the said pleadings, this matter will be listed together for hearing. We listed 3 weeks, we think.
Lordship, then it can be listed, can be listed on 22nd or 23rd of May. After
About 4 weeks.
any date after 22nd.
Why are you going to Mexico? No, because you always, I mean, in jest, he always goes to exotic places. So maybe Mexico or maybe to Iceland or something.
Sudan can be one of the choices.
So you'll be traveling.
I have been traveling.
I understand, yes. So we listed the other matters. List on 26 first, then we see if the list on 26 is done. Then if they are complete, then we'll put a fixed date of hearing. As